that and reflect the know-how of cyber ninjas, period, close quote. That's their argument. There are no facts. There are no affidavits. There's nothing to that. Arizona are required to publicly provide its operation materials for certified voting systems that can be examined by the public. So, Your Honor, simply on the failing to meet the standards of the state to withhold this information, somehow engrafting the Arizona Public Records Law onto Rule of Civil Procedure 5.4. Again, it makes no sense whatsoever because it's completely irrelevant to the 4-point test of Rule 5.4. But, I mean, let's take the argument for what it is. They are arguing that it would be in the best interest of the state to overcome the public's constitutional right of access to federal court records and proceedings because it, quote, would negatively impact both current and future discussion with the Senate's contractors. Your Honor, I don't even know what that means, but I mean, clearly that doesn't overcome a constitutional right for speculative conversations in the future with unknown contractors with the state Senate. In conclusion, Your Honor, the fact that Cyber Ninjas has not even made any showing whatsoever to meet its burden under Rule 5.4 is the reason to deny this motion. There are 4 factors that Cyber Ninjas must meet to establish specific facts in support of withholding Exhibit D. They do not even get past the first factor, which is where Cyber Ninjas must show, quote, an overriding interest that supports filing the document under seal and overcomes the right of public access to it. Cyber Ninjas has not tried to do that, and they cannot do that, and for that reason, their motion should be denied. Thank you very much.
Thank you, Your Honor. And a lot of ground has been covered by my colleagues, and I will endeavor to avoid repetition. I want to talk a little bit about the procedures. The procedures, and then we can talk about legislative privilege a little bit. So I understand that there are 2 main types of procedures that we're actually talking about here. Obviously, I haven't seen what they filed under seal. It's not a lot of pages, but it seems there's a set of procedures related to chain of custody and the manner in which the hand count is being and the count is being conducted, and then there's a set of procedures related to security of the ballots. I think that a review of the elections procedures manual and the relevant sections that are analogous to the kinds of procedures that Cyber Ninjas should have produced publicly shows why those are simply not confidential or trade secrets. If you look at Chapter 11 of the Elections Procedures Manual, it discusses at very significant detail how a hand count is supposed to be conducted. And those sorts of things can be provided to the public without endangering any trade secret. In addition, Cyber Ninjas has provided cameras in the Coliseum and a live stream so that the public can watch what they're doing. And I do not understand how they could have cameras and yet say that what they're doing is protected by a trade secret. As for the security procedures, the analogous procedures are set out in Chapter 4, Section 3 of the Elections Procedures Manual. You know, they say how you're supposed to secure hardware components of the physical security of an electronic voting system. They have to be permanently labeled, they have to be inventoried, they have to be stored in a secure locked location, they have to be sealed, they have to be safeguarded from unauthorized access. Why Cyber Ninjas cannot provide to the public procedures analogous to that, I simply don't understand, and I don't see how that's a trade secret. In our brief responding to Cyber Ninja's motion to seal, we provided declarations from 2 experts on election audits and security, and I believe those helpfully explain why these points are especially true in the context of election administration, in which very few things are trade secrets, because part of the point of elections and in particular audits is to reassure the public. So you want the public to know how you're doing things so that at the end of the day, when you come out and tell them what the result is, they trust that. Amend those declarations, to Your Honor. Briefly on the issues of legislative immunity, On the civil process clause of the Arizona Constitution, it does not say it is an immunity from suit. It says legislators are protected from civil process. The only Arizona case on point, Smith, says, well, that means that protects them for a does not support the claim that Cyber Ninjas is making here. Perhaps there is further than that, as the Wisconsin case Benno we cited says it may. It would pertain to ensuring that legislators can be physically present, so during the session. Nothing in this lawsuit is preventing Senators Fan or Peterson from being at the legislature while this litigation is ongoing. And furthermore, that clause is by its terms limited to members of the legislature. It does not extend to cyber ninjas. Requiring cyber ninjas to comply with state and federal statutes and the Elections Procedures Manual will not prevent Senators Fan or Peterson from attending to their legislative duties. As for speech or debate immunity, as Your Honor knows, the heart of speech or debate immunity is speech or debate in either house of the legislature, and the power of that immunity declines as you move away from that. And it reaches beyond pure speech subject to the Fields test, which is binding on this court. And there is no way, as Mr. Gaona explained, that Cyber Ninjas conduct meets the Fields test. Preventing Cyber Ninjas from violating Manual will not impair the deliberations of the Senate. No one is seeking to enjoin the legislature from considering a bill. The question before this court is not whether the audit may continue at all, but simply whether, in the course of the audit, Cyber Ninjas has to comply with the law, and requiring them to comply with the law will not impair legislative deliberations. If Cyber Ninjas was engaging in bank fraud in the course of the audit, that could be addressed by the courts without impairing the legislative deliberations. Obviously, I'm not alleging that. I'm making a hypothetical to prove the point. If they were engaging in the destruction of property in the course of an audit, similarly, the courts could exercise jurisdiction over that without preventing the legislature from deciding how to write election laws in the future. Manual are binding on the audit. And indeed, the Gravel case from the United States Supreme Court makes the point quite clearly that criminal conduct by aides of legislators is not protected by the speech or debate clause. And as the court knows, violations are misdemeanors under Arizona law. Finally, Mr. Langhofer suggested that the defendants could simply promise that they're not violating the law. But of course, that's not how our adversary system of justice. They are not there to analysis, to cross-examination, and to the presentation of contrary evidence. So we would ask the court to deny the motion to see.
Thank you, Mr. Bendor. All right, Mr. Wolf, as counsel for the moving party.
Yeah, I'd like to.
Sorry, Your Honor, I was on mute. I'm just going to state that we're, in no position to argue given the circumstance and just going to stand by the filings.
All right. Thank you, Mr. Wolf. Everyone, we will take a short recess while the court considers. I'm going to leave the interface open, so please remember anything you say or do during the recess may be visible to others watching this hearing. It'll take me at least take a short break. By all means, feel free to do so, but please be back in 5 minutes so that once I'm ready to retake the bench, everyone is here and ready to proceed. All right, thank you.